Okay, recording started. All right. So where were we? All right. Uh, in order for you to talk about breach of contract, it is very important that you must establish 7 elements of contract that I've discussed with you. Okay, first you must identify from the question given that there are the presence of 7 elements in the contract, namely proposal, acceptance, consideration, and also the intention between the parties to create legal relationship. Subsequently, you have to see the capacity of the parties, whether they are minor or in sound, there's a unsoundness of mind. Okay, then you must evaluate. This is favorite question. I have repeated myself in the previous class. I hope you guys are with me. The free consent of the parties are very, very important. This is where your fraud, misrepresentation, undue influence set in. All right, that means you enter the contract, but it is not according to your free will. So this amount to a reshaping factors to the contract, to the validity of the contract itself. This is where we can rescind and make the contract void. Okay, can follow me so far? And of course, lastly, the last element will be the legality of the contract itself. That means we are talking about whether the purpose and also the consideration of the contract, is it lawful? If it is unlawful, automatically the court response is the contract is void. Void, it's not voidable, it's void. Okay, so get the concept right first. So after you have established their presence of these 7 elements in the contract, subsequently, you look at the terms, the content, what is the isi kandungan inside the contract, okay? Namely the terms, warranty, denominate term, and as well as sometimes there is presence of some exclusion clause, Okay, so far can get me. So these are the topic that we want to look about and we want to discuss about in this lecture. And after that, after the content is okay, then we look at how do we discharge our obligations. By right, once you sign the contract with a party, it is compulsory for you to go with the contract. That means you must perform whatever that you have laid down. One by one, you have to perform. There are a few conditions that we can discharge the contract. And then the damage only arises, usually, it's not always, but usually arise when there is a breach of contract. Okay, right? And there are some other issues that you might need to discuss. For example, extrinsic evidence as well as territorial jurisdiction. Like in my previous examination, it comes out, So I got a shock. So never mind. We go on with the class first. So talking about the contents of the contract, it's very important for you to distinguish between, sorry, on and off got students coming in. So I have to admit them, right? So you have to distinguish the terms and also the representation. They are not the same. So, okay, we do not have a strict definition under Contract Act 1950. Your approach shall be very simple. Whenever you have an issue with contract itself, first thing that you should refer would be Contract Act 1950, this one. If you could not find any definition, or you cannot, how to say, to find the meaning of that particular words from this Contract Act, then only you move to the definition of case law. So we do not have the Contract Act itself is silent on the issues of terms. So we refer to Ching-it development against Tapak Heights development to find the meaning of three things. This is also very similar to English law. We have a condition, which is termed by our Gopal Sriram as fundamental term. Okay, this one, if it goes to the root of the contract, that means to say the pokok of the contract, sas pokok. Okay, so you have the right to discharge himself. Okay, so fundamental term, I think this one is quite simple. And second one is warranty, which is a less important term. Okay, and we have a denominate term. That means we are not sure whether this is a term, a fundamental term, or less important term. So this is based on the construction of the contract. That means to say, how do the court construct this document, interpret this document? If it goes to the root, the contract, that means we fall back to fundamental term. That means to say, we will held this so-called uncertain term to be a fundamental term. So thereby you go to discharge. Okay, discharge, totally no need to perform if there's a breach of fundamental term. Okay, can understand? Okay. So next, what do we see in the contents of the contract? Okay, sometimes there would be, and most of the time in practice, that there will be an exemption clause. Exemption clause work in several ways. For example, it seeks to limit the liability of the party. Okay, it depends us. And how to say? It depends who made the contract for you. If the lawyer or the counsel is a neutral one, probably they'll explain to you. If you enter into a contract with some, you are not paying for the contract, for example, you have to be careful with this exemption clause, because it will limit the liability or even exclude the liability of a party. Okay, so sometimes don't save the money. You have to let your own counsel or lawyer to read the contract. Otherwise, you'll fall into this so-called exemption clause, and then you cannot claim your liability later. Okay, so we have statutory provision for this exemption clause as well. This one we refer to section 62 of our SGA. This is only limited for the product liability. Okay. And in order for you to enforce this exemption clause, you must obey two doctrines. Okay. What are the two doctrines? The first one being doctrine of incorporation. Okay. The meaning behind that is what the exemption clause must be black and white inside the contract that you have signed. Okay, and then you must have prior notice. That means before you sign this contract, you must have known about the existence of this exemption clause. Okay, this is called doctrine of incorporation. And then second principle that govern exemption clause would be contra proferentum rule. Okay, this term is very important. That means the party that rely on exemption clause. Okay, usually who? The one that want to void the liability, Okay, he or she that rely on this contra proferentum rule shall, there's a strict interpretation by the court in such a way, okay, it is strictly interpreted. That means the clause itself, the court will really scrutinize into it, and then the clause itself must be certain, clear, and unambiguous. That means no fishy or no vague area inside this exemption clause. Then only the court can enforce this exemption clause. Otherwise, cannot be enforced. Okay? Okay. After you have screened through the contents of the contract, then we should talk about how do we discharge our obligations with the contracts that is already formed. Okay, there are actually 4 ways you can seek to discharge the contracts. Okay, we'll talk about the first one being the performance. That means you actually perform whatever the terms and warranty or innominate terms inside the contract. You do whatever that is stated. Okay, so as you all know by now, I love to classify things, right? So I make it very simple for you. There is one principle, 4 exceptions, and 1 timing clause in relation to this performance thing. Okay, the main principles you can find. That's why I always say, if you have this definition, fall back to your contract act first. Okay, fall back. Number 1. So section 38 contract act. Okay, you may have a look now. So it said that the performance of the obligation of the parties must be entirety. That means to say it must be performed as a whole. Okay, keseluruhan. And then it must be precise, and also exactly. You cannot vary, you cannot perform, okay, I ask you to do in the morning, but you do in the afternoon. No, it's not this way. So these are the, sorry, many people coming in. Okay, so you must perform entirety, precise, and exact. You can infer this from section 40 as well. A lot of people associate section 40 with breach. It could be true, but it's more on refusal or disable themselves from performing the obligation. It is an arguable area whether this is really a breach of contract, because the provision of section 40 never talk about breach of contract. Okay, so after finish this main principle, we go to 4 exceptions in relation to performance thing. Okay, we have doctrine of severity. That means the contract itself can be split into 2 or 3. This is the doctrine whereby you don't have to perform the whole contract if it is dividable. That means to say we can divide or split the contract into several contract. Okay, but this is a matter of construction by the court as well. You cannot simply I want to separate it, I want to split it on your own. Cannot. This one is to the court to construct the documents. Okay, so I give you an example here. Contract to build multi-sports complex, for example, as well as basketball court and swimming pool. In one contract, okay, we have 3 things: multi-sport complex, basketball, and also a swimming pool. But defendant only built multi-sport complex, basketball, not the swimming pool. So you have to rely on the severability clause. Okay, I'll show you later of the what we call the slides now. Okay, so this is the first exception. Second one is the perform contract, or should I say the contract, most of them are done. Maybe 70–80% was done. Remaining certain specification is not done. So, okay, you cannot force them to, you cannot just split specific relief, compel the person to do. For example, it's a construction of a house. He finished the house for you, there's a well structure, only the crystal light is not installed, and probably your cabinet is not installed. So this, again, we have to see. Okay, the contract itself is about the building a house, but certain elements of this house is not included. Maybe the workers run away or whatsoever the problems happen on that particular contractor. So what you do is, actually you cannot like sue for breach of the term of the contract, the fundamental term of the contract, but you can engage another contractor, and then what you can do is you repair or you make it better in accordance to the exact contract and claim damages accordingly. Not as a whole, the cost of the house could be 1 million, but the cost of installing a crystal light and also the cabinet could be only 5,000 ringgit. So you claim only 5,000 ringgit, and the other party cannot be compelled to perform the contract. All right. So you get what I mean, because the contract was almost wholly being performed already. Okay. And then we look at the third exception. The performance was prevented. Okay, that means to say, from this example, Smith construction case, okay, they want to build a house, and then subsequently, the house was built beside the neighbor. They cracked the wall of the neighbor. So no choice, because you already disturbed your neighbor, you have to stop the work. So this is what it meant by performance was prevented. Not to say I don't want to do. Now I was being prevented, because if I continue to do, my neighbors, the whole floor will get collapsed. All right, you get what I mean, Okay, and the final exceptions would be if the breach is not involved to the fundamental of the contract. This is almost similar, lah. I mean, the same case also we apply building an estates against AM corner, like I have talked to you just now. It's almost the same principles here. All right. Okay, so this is what I mean by the severability clause. All right. So usually, it will be provided, if the provision itself is not being split. Sometimes the whole contract, you can held it void. Okay. So this is how we formulate our clause in order to protect our client better lah. All right. So you hear about this term before, isn't it? Quantum meruit and also quantum verbate. So it simply means do not confuse yourself with this sort of Latin words. So you try to understand the literal meaning of these words. Okay, quantum meruit means as much as he deserved. All right, quantum verbate means as much as it was worth. Only that. All right. So how do we speak? You must relay back this concept with the illustration of section 65, 66, as well as section 71 of your contract act. For example, a singer by right should sing six nights, but then he only performed 5 nights. So you pay him according to this principle, quantum meruit, okay, as much as he deserved. All right. No, quantum means the amount. Performance means you do something. You do not differentiate this concept. All right. This is just how much he deserved only. You see, the quantum means how much. Okay. Just interpret from here. That means it is related. If he does not perform the contract as a whole exactly or precisely according to the terms, then we will quantify how much he had performed. You get me? Like you are supposed to send me 100 products, but then subsequently you only send 90. I only pay you 91 lah. Then I want to pay you the 100 products that you didn't send at all. You sent 90. What about the remaining 10? So I can only pay you the 90 for the 90. So this is why this concept set in. All right. And strictly speaking, section 65 and 66 does not apply to breach of contract unless there is total failure of consideration. You try to understand this LSSC development better, in which total failure of consideration means you did not perform anything. The contract has yet to start. I mean, it is just from scratch, nothing. One stone also you never built for the house. That means there is a total failure of consideration. All right. This is the time whereby you can plead for rescission. Okay. Get this concept well. Otherwise, it's only claim for damage, and then subsequently you refer to the remoteness of the damage. All right. And then okay, we look at the last issue about performance. Okay, sometimes we will have a timing clause, inside the contract itself. That means it will be constructed in such a way this timing is really an important issue lah. It's really essential to the contract. You must perform your contract according to the time provision given. Otherwise, the contract will last for life indefinitely, correct? So this is why time clause is important. Okay, so we fall back to Contract Act to evaluate the meaning of time. So you can find the so-called the meaning in section 51 as well as your section 47. Okay, very important for you just to memorize these these sections for the purpose of exam. Okay, so section 51 provide that the performance of any promise may be made in any manner or at any time which the promise prescribes or sanctions. This is what I said. Okay, can be provided as one of the clause inside the contract. So this is given in section 51. Okay, so section 47 Contract Act, whereby the contract, a promisor is to perform his promise without application by the promisee, and no time for performance is specified. The engagement must be performed within a reasonable time. This will be a question of fact. That means if your contract itself is silent, now no provision at all, no clause to talk about time. So the court will step in and then we'll see what kind of contract is it. Is it about, for example, I contract with you with the sale of banana. Okay, this banana can only last about a week. Okay, so this is based on the question of facts. You cannot send me after seven days, what, correct or not? Or you cannot ask me to pluck from the tree and then to send you 2 weeks later. The banana will get found, isn't it? So this is a question of fact, okay? So I hope you can understand this time. Okay, so what are the clause? I mean, what are the other provisions of Contract Act that you must look at will be section 56 rule 1, 2, and 3. And please try your best to understand it. Very important, because this talk about the whole contract is voidable, If, let's say, for example, if the time is essence, that means the time is really so much so important to the parties. Okay, if you fail to perform on time, the contract is voidable. Okay, voidable means one party has the option to make the contract void. So after the contract void, what it will becomes is at the remedy that you seek will be section 65 lah. Okay, 65 and as well as section 66 to be read interchangeably. Remember the case of Yong Mok Heng? All right. Section 56 rule 2, when time is not essence, that means the time is not important here. It will not, the contract will not be voidable. Okay. But the loss, you still can claim. Okay. You still can claim, provided you can prove it. Okay. So section 56 rule 3 further provide that, okay, if the time is essence, but the party subsequently, I give you an example, easy for you to understand. I contract with you to sell the banana. Okay. And then by right, I put there, the deal should be complete within 7 days. But subsequently, you have a problem. For example, you are the distributor of the fruits. You say that, oh, recently the banana is not so popular among my customers, Okay, I send him a notice, send me a notice, for example. Okay, WhatsApp me, say that, okay, Chi, why don't you send the banana 10 days later? If I accept, if I accept it, okay, I reply, okay, in my WhatsApp, I agree. So it becomes not voidable, you know, even though the time is essence clause is readily inside the contract. But once accept, you cannot make it void. Okay. But there's a but here, you can claim compensations. Okay. Provided after you're okay, you send him a message, say that, or notice that, we call notice lah, okay, say that, okay, I reply him lah, okay, I said, I accept whatever you have proposed, 10 days, but I reserve my rights to claim from you, okay, because definitely some of my bananas will get rosak one, isn't so? So this is very logical, okay, so in order to interpret this time is essence clause, it is saying that the time of essence could be waived. Okay, if the party wanted to claim, he or she must give notice. Okay, must give notice. Okay, but once the extension of time had occurred, for example, the banana issue just now, if I already agreed 10 days, the court will automatically assume that time is not an issue. That means to say you all already negotiate and time is never an essential component to the contract, you know. So once it is how to say, the extension already occurred, I mean, among the negotiations, sometimes in practical worlds or world of business, it always happen. When the parties already agreed, then you cannot fall back and then claim, oh, it's essential. But whereas in the fact, you said, oh, extension of time is allowed. No such thing, okay? So we finish with performance. Second part, how do we discharge a contract, would be new agreement, okay? So we fall back to section 63 and 64. Section 63 said that effect of novation, rescission, and alteration of contract. Novation means you override the old contract with a new one. That means you substitute. That means this contract is something wrong, something I cannot perform inside the contract. So you enter with the other party for a new negotiation, and then you draft a new contract in order to replace, okay, to replace the old contract. So this will make both parties happy. All right. So this is what it means by novation. And the second issue that you have is rescission. That means you rescind the contract, no need to perform, and alteration of the contract. Okay. And section 64, this one is quite clear. Promisee may dispense with or remit performance of a promise. Okay. Here we look at the slightly, I think this part is not so difficult. We look at frustration. So what does it mean by frustration? Frustration in Malay word, it means kekecewaan, you know. You rasa kecewa kerana contract ini. Okay, so frustration, you remember how I teach last time, is you must define it and then subsequently you must talk about the effect or the remedy related to this issue. So your answer will be much more systematic lah. So again, we try to find the meaning of frustration inside the contract act. Okay, so we cannot find exact word of frustration, but we can find the word impossible. Okay, where do we find this impossible? Okay, section 33B, okay, of your contract act. Okay, events becomes impossible, such contract become void. Void means other contract, no valid contract. Okay, and section 57 subrule 1, an agreement to do an act impossible in itself is void. Okay, and we look at this section 57 subrule 2, after the contract is made, becomes impossible, or by reason of some event which the promisor could not prevent. Okay, I highlight the word could not prevent, becomes unlawful becomes void when the act becomes impossible or unlawful lah. All right. So, and one more section that we should look at would be section 57 sub-rule 3, in which where one person had promised to do something which he knew or with reasonable diligence might have known and which the promisee did not know to be impossible or unlawful, the promisor must make compensation to the promisee for any loss which the promisee sustained through the non-performance of the promise. Okay, so this is very much in line with the English law, Davis Contractors against Fareham UDC. Okay, which had actually summarized what are the circumstances whereby the frustration can occur. Okay, there are three circumstances. Number one, it will be act become impossible or unlawful. Okay. Second, the event itself is supervening, it's like unforeseeable, it's unforeseeable. Initially, when you contract with somebody, you may think this is okay, this is lawful. But what if there is a war happen? What if there is a natural disaster that happened? Okay, so it makes the subsequent contract, I mean, after you have signed, then only we go to war with some other country. So we cannot perform it. So this is what we term as frustration. Okay, and third, and being the most important as well, the said act itself must not be self-induced. Okay, you try to remember this and put it into your examination. Okay, so what are the examples of frustration? Okay, you see my heading one more time. Usually here will be definition. Okay, statutory definition. Okay, subsequently we'll talk about remedy. Okay, remedies. So what are the examples of frustration? Number one, it could be the subject matter becomes radically different from the original. Okay, that means the whole thing becomes so different already. Cannot even be done. Impossible to be done. Okay. So second, new changes of law, government intervention, or even war after the contract. Okay, after the word is after, not at the moment that we have entered, If the moment that we enter the contract, it is already unlawful, then you go for your section 24. Okay, the consideration itself is unlawful. So automatically it will be void. So this one is after, after that only it happens. Okay. And the third one being subject matter is lost or destroyed. Okay. The fourth one, failure to obtain license. Okay. Initially you contract to get a this is lesson pembalakan lah. We just talk about lesson pembalakan lah. Very easy. So you contract with somebody, said that, okay, we are planning to develop this jungle, and then we're going to lumberjack all these activities there. But subsequently, the whole contract, you cannot perform because you do not have this license to enable you to carry out whatever the obligations inside the contract. So this will be deemed as a frustration. Again, I said the Malay word for your easy understanding, it will be kekecewaan. All right, kekecewaan. And should any injunction towards the subject matter of the contract, sometimes you cannot perform it as well. For example, I plan to sell this Rolex watch to you. And what happened is, got a Mareva injunction. Okay, somebody prevents me from dissipating my assets. So injunction towards this Rolex watch, you cannot perform anymore, right? Because you have to obey the injunction order given by the court. So this is how it happens, All right. Okay, try to understand this. And we have force majeure clause. Okay, force majeure clause, usually you cannot claim frustration under force majeure clause, all right? Because the thing already, you anticipate, oh, these are the conditions that might happen. For example, flood, for example, earthquake lah, tornado, whatever you put inside already, then automatically, usually the force majeure clause will provide a solution uh, to the contract itself, whether it is void or how, can extend time or how. All right. So the solution is already provided inside the force majeure clause itself. So therefore, you cannot say that, oh, force majeure, I use this clause to say that the whole contract is frustrated, because the effect of frustration is only one, it's only void. Okay, so cannot, so if it is listed inside, just remember cannot claim. Okay. And so what are the remedies and also the effects of frustration? Uh, you have to look at section 66 as a remedy, because we talk about the effect of the void. It's already inside your provision, okay? Because section 57, rule 2 and 3 said that it is void at the time of frustrating event happen. Okay, not the same as illegality of the contract, whereby we have talked about this during the 7 elements of contract. This is not void ab initio. Okay, this is void at the time where the frustrating event happens. Okay, try to understand that, because sometimes you build a house. Okay, you build a house, halfway already, 50% of the house is completed, but unfortunately the war happened. Okay, some unlawful thing or some impossibility of the act happens, which is not foreseeable by the parties. So you cannot void ab initio, that means from the beginning it's very difficult. The house already 50%. So section 15, if you appreciate closely, you have to still pay the parties for the 50% that he already contributed. Okay. And section 16, subrule 4, further provides that it could be treated that part as a separate contract itself. Okay, try to understand this provision, and these are the important remedies and also the effect of frustration. Okay, as easy as that lah. Actually, not so confusing lah. Compare with our reshading factors to free consent. I feel that that part is much more difficult. I think when the time I studied. Okay, last we talk about breach of contract. Okay, breach of contract, there are two top lah. First, okay, the contract could be refused, okay, to perform or disable himself from performing. Some people put it as in Malay word will be penolakan contract. I refuse or disable myself from performing, section 40. But in our practice, it seems that we are so used to use this word to define breach of contract. Okay, but there is some academic debate over these small issues okay. Anyhow, okay, you look at section 40, what it said: contract has refused to perform or disable himself from performing his promise in its entirety. The promise may put an end to the contract. Okay, and second is the breach of fundamental term of contract. Okay, Chinese development against you use the same case. No need to confuse yourself with so many cases, as long as you get the fundamental principles of law right, I think you should be okay. It's not about the regurgitation of all the case law inside your answer sheet, but rather you appreciate how the operation of the law to the question, to the problem scenario given. I think that one is more important. Okay, so as a remedy, you can actually continue and claim the damage. You can continue with the contract, okay, even though there's a breach of fundamental term of the contract, but subsequently you claim damage for that particular breach lah. Okay. Second would be terminate the contract. That means to say you discharge the contract. No need to do anymore. Tak payah buat. Okay. Whatever the payment, whatever the your remainders of your obligations are no need to perform. Okay, no need to, and you can claim damage. Claim damage relating to breach of contract. You may need to refer back to your section 74 and also section 76. Very important. And I think I have repeated this. If there is total failure of consideration, then only you can use section 66, okay, to make the contract void, okay. Like the example I have given you, you have not even put one stone to build a house, okay. Nothing is done to the contract. So this is where you can apply the section 66, all right. Okay. So last we no, not the last, this second last, we look about the damage. Damage classification of the damage don't get too much confusion. Usually it applies to the breach of contract. Okay, question. Usually, okay. Broadly, you can classify your damages into liquidated damage, in which you must use section 75 of Contract Act, okay, and also mass telecommunications against cubic electronics. If you cannot remember, just remember the cubic electronic case, whereby if there is a liquidated a certain damage clause, LAD clause inside the contract itself. For example, if there is a breach of fundamental of the contract, okay, so and so, the party Chi is liable to pay 1 million to you, okay, as liquidated a certain damage. So that 1 million, if I really breach this contract, you do not need to produce any evidence. You can rely on this clause and then claim 1 million from me in the court. All right. So this is what it means by liquidated damage, section 75. And if it is unliquidated, that means you have to produce proof. Okay. The damages itself could be substantial damage, nominal damage, and as well as exemplary damage. Okay. Other classification will be pecuniary and non-pecuniary loss. Okay. Don't forget, sometimes, not always. This one I hardly seen in past year question, frankly. But this is inside your syllabus, So you will have specific performance, whereby you have to flip through your section 11 until section 29 of your specific relief act. Bear in mind, specific performance is something very, very unique. Okay, it doesn't, usually the court will not simply award this sort of remedies to the other party, because it already against the free will, If the relationship already turns sour, how do I expect you to continue with the performance of the contract? Isn't so? How do I compel you? Okay, to make your understanding easier, I think I will use the house thing. If let's say the house is already half done, but you are really not happy with the fundamental terms, you say the whole structure is like shaky, and then it's like when I went in, it's almost collapsed, this sort of thing. How do you expect me, for example, the defendant, complete this house and compel me to complete this house to you? It will be a never-ending story, So the court usually take an attitude that if the monetary compensation is adequate, then it will not compel somebody to do. Okay, if it is a contract for service, cannot also compel. And if the whole thing sometimes can last for more than 3 years, for example, another thing, a good example here will be a house. It will take about 3 years to complete, for example. How do court has the time to monitor the progress? So this one, the court can ask the other party to give specific performance. Okay. Injunction, you have to look at section 50 to 55. So injunction, the main law, the substantive law is actually derived from Specific Relief Act 1950. A lot of students come to me and then straight away go and talk about Order 29. There's a distinction between Order 29 as well as Section 50 to 55, Section 50 to 55 provide for the fundamental where is the power where is the power of court to grant injunction coming from, Order 29 is just your ROC, rules of court, procedural rules, So you have to distinguish, you don't put Order 29 when you talk about contract law in general papers, okay? So assessment of damage is very not so difficult, and it's quite simple as well. You just need to discuss the remoteness of damage. Okay, remember one case enough lah. Okay, Hadley against Baxendale. This one, H against B, we always memorize. Okay, universally this principles of law, the two limbs shall set in determining the remoteness of the damage. And in Malaysia law, it is already been codified inside section 74. Okay, section 74. That means ordinary laws which arise naturally in the usual course of events. That means to say the losses is normal, It's like this will definitely happen, okay, if you breach the contract, all right? So ordinary loss, the second limb will cover, okay, extraordinary losses. The good example here will be usually psychiatry loss, okay? Psychiatry loss or mental distress, or all this kind of non-pecuniary claim, okay, whereby extraordinary losses you could claim, provided both contracting parties knew about this thing exists, okay? That means certain degree of foreseeability must be there. It must be within the reasonable contemplation of the parties. That means both parties must have aware, take note, okay, knowledge about this psychiatry thing, okay? So these are the concepts that you must know. And mitigation of damages means you cannot bear the loss and also the damages free flowing. Okay, the good case here will be Kerbatasan timber extractions against Chong Fa Shing. And you must discuss a little bit of the timing of assessment of damages. When does the damage occur? So you can assess the damage accordingly, X factor, and also contributory negligence. But this one, don't simply plead. If the fact required you to do so, then only you plead. All right? So last issue would be extrinsic evidence. Extrinsic evidence, you will need to refer. No, you have no reference during the examination. You have to memorize. Section 91 as well as section 92. Okay, Section 91 Evidence Act itself already provided. Whenever you have a written contract, you have a black and white thing, except for the contract itself could be introduced in the court, you cannot bring in any other oral evidence, like, okay, this contract said so. But hey, no, that day we have a discussion over the phone, said that the term should be in the other way. It's not the case. So the section 91 Evidence Act, okay, no oral evidence can be introduced. I hope you're clear. And exception to parallel evidence rule will be section 92, okay, A to F, okay, A to F, you must have at least a little bit ideas, about these provisions, okay. Also not so difficult to understand if you read your evidence paper subsequently, all right? And then this is something very new. Last year, I tell you, I got a shock, because the question asked in such a way that I could not write what is the cause of action in the contract question itself. Instead, they ask about whether you can sue the defendant in Malaysia court or not, whether there's sufficient evidence to support your, how to say, your claims or not. So this is something very novel, Okay, but I beg that you must cover lah. You must at least be prepared for the so-called extraordinary questions, okay, that might be asked during CLP. So this is about the territorial jurisdiction of the court. If you look at CJA, section 23, sub-rule 1, it talks about the High Court territorial jurisdiction, okay, and section 99A, it will govern, the subordinate court, it will govern the session court as well as the magistrate court. All right. All right. So we finish our contract now. Well, you still have a lot of time. Thank God. So what we do next, we do. Do you have general papers 2021 with you? Okay, I need you to go to your 2021 paper because I'm thinking of talking about this our statement of claim here. Do you have it? Hi, you all have it? No. All right. So you have it, huh? So okay. So general rules of drafting a statement of claim is you straight away draft this statement of claim. You do not write extra thing. You do not write the rules of pleading like older 18 lah. You must plead facts, not evidence, not law. Okay. No. You don't have to. You straight away just draft a statement of claim for your question 1C as well as your question 2C. Okay. So how do we read this question? All right, I try to enlarge this. I share the screen with you. And okay, we look at general papers 2021. Okay. So first, what you do, you must see who are the parties first. Okay, who are the parties? Okay, this is quite a straightforward question because the parties is only Mr. Derek Gulliver and Mrs. Anna Gulliver with this who we call this easy come, easy go Sendirian Prahat. Okay, these are the plaintiffs and this is the defendant, one and only defendant. So this year punya question not so challenging, I would say. All right. So okay, you look at this facts, or is everybody having this? So I can actually refer to my tape. I have a tape with me in order to speak to you better and how I draft my statement of claim. All right.
So I don't have this question.
You don't have it's actually in the group, Are you with us in the group? I sent to the group,
Yes.
or you can open up with your. Did you see inside the group? Otherwise, I have to keep sharing the screen and exchanging. I have tried to split the windows, but it doesn't work well lah. It doesn't work well. Let me send in the group one more time.
I found it, sir.
You found it, Wow, very good.
Yes.
Okay. So first thing first, we have to decide. Okay, we have to decide which court to sue. Correct? Okay. So we go to the question. Slowly we go to the question. So you can see we look at where the defendant is staying. Easy come, easy go Sendirian Berhad. As we all know, why we need to see where does the defendant reside or having business? Because it's important. This will determine our forum of convenience, Your SOVA against Kasih Sayang case, remember? We have to choose the place that is convenient to our defendant. All right, so I hope this is very clear. Okay, so you choose Kuala Lumpur. All right, Kuala Lumpur, because easy come and easy go is from Kuala Lumpur. They sell the land there. All right. And are we able to agree that the right court to sue is High Court of Malaya? All right. Anyone can tell me why we sue in High Court of Malaya? Simple question, this one. Okay, very good. The monetary value of the claim is already 1.5 million, isn't it? 1.5 million. Okay. And as well, you can refer here, the loss suffered is more than 1 million. So we are agreeable that we should put our claims in the High Court of Malaya. Okay. You cannot just sit in the High Court of Malaya at Kuala Lumpur, and then you must continue, with this sentence in the federal territory of Malaysia. Okay, every single words try as much as possible. Do not make any what we call mistake. Okay, this one is I just draft it today, actually. Civil suit number. All right. Okay. Civil suit number, and then automatically you put a dash 2023. For example, for your upcoming exam, you put 2023 dash, and then uh, uh, usually how we do is the court will give us a number, read number, okay? This one you do not have to worry about. And then subsequently you must write between who and who. Okay. The first one here would be Derek Gulliver, and the second plaintiff must be Anna Gulliver. Okay, sometimes to let the examiner aware that you are knowing something, you have to put the NRIC number. Okay, you put the our 14 digits number, okay? Sorry, the 12 digit numbers, okay? So you have to put the digit as XXX, something like that. This is my style. Of course, you can follow your own style at your own liberty, right? So we do not have, I did not share the screen. I thought I'm sharing it, no, wait, wait, okay. Are you all able to see the SOC? No, cannot. The contract. Derek Global, Anna Global. Can see or not? Now can see, very good. All right, so we proceed. So the parties here, we do not have much issue. And easy come, easy go will surely be your defendant, because he's the one that contract with your plaintiff. Okay. And then you must put the company number. Company number, you can draft whatever you like, so long it is you put company number because it's Sendirian Berhad. Okay. And then lastly, you put defendant. Okay. And then followed by these words, statement of claim. Okay. Then you underline. Okay. So far, understand, the heading, the initial part of our statement of claim. You must get the format right, you cannot simply write, must get the format right and must get every single words in the statement of claim right, because you cannot afford to lose mark in this part. Okay, this is playing a very crucial role, whether you pass or not. You don't yeah, I have. Don't worry. The medical negligence SOC. I'll be discussing 4 SOC today since we have time. This will cover medical negligence for year 2021. I think 2021 good. Okay. So, okay. First, you go to the first paragraph. The first paragraph of your statement of claim. You must start with the introduction of plaintiff. Okay. Introduction of the plaintiff. You must say the first plaintiff is an individual, And then you must tell where he lives. Okay, whose residential address is at nombor X berapa, Jalan ABC. Include the postcode, This one is a very precise thing to show that uh, to show to the examiner that you are actually knowing how to draft an exact statement of claim. You cannot just put the address at Kuala Lumpur and Malaysia, finish. No, you add in some fictitious material because the fact does not provide you, so what? So the house itself cannot be in Jalan ABC, isn't it? It must be in some nombor, So very important for you to realize this, and you must draft like exactly where is the exact location of your house. Okay, important, And then you introduce the second plaintiff here, which will be our Anna Gulliver. Okay, the second plaintiff is an individual whose residential address is at nombor X Jalan ABC as well, because they're husband and wife, isn't it? So they stay in the same house. At all material time, the second plaintiff is the wife of the first plaintiff and a house purchaser. So this one also I put house purchaser. I did not elaborate further because you can get it from the first paragraph of your question. They are actually were looking to purchase a home, isn't it? So you can put further description to support, to introduce to the court what is the role of this particular plaintiff. All right, you just make it very simple and based on the question given. Okay, based on the question given. Okay, then third, okay, I must align this one on my it should be in line, cannot be like that. I don't know how it goes to like that. Okay, the third defendant, the third paragraph, you must introduce the defendant. Okay, the defendant is a private limited company registered under Companies Act 2016 and having its registered office, or you can say business address. It doesn't matter because it will never affect our service. Okay, the service, as long as it goes to the register office or business address, it is a proper service. Okay, so no issue. Again, you're right. The fictitious one, 1, 2, 3, they stay in the same row, Jalan ABC, Kuala Lumpur, Wilayah Persekutuan, something like that. So what is the role of this defendant in this particular writ action? You must write and introduce to the court. So at all material time, the defendant is developer of housing projects. So this is what you should have told the court about. Okay, so you already told in plaintiff as well as defendant. So the third element, or I will say the fourth paragraph here lah. Okay, so you must describe to them, to the court, what exactly happens. Okay, it will be better for you to draft statement of claim chronologically based on what happens inside your question. Okay, so we look at what happened actually. In the first paragraph, you can see actually Mr. Derek and Mrs. Anna, they wanted to buy a house. Then they went to this developer sales campaign. Okay, easy come, easy goes sales campaign. Subsequently, they were greeted by this marketing manager of the developer, Mr. Denzel, which made the following representation to them. Then subsequently, they buy the house, right? So this is roughly the story. So during examination, what do you need to do? You must say that there is a contract already. So why I say there's a contract, because they already agree and then they buy the house already with 1.5 million, right? So there is a contract in between the parties. And some more, there's a catch here, Okay, you can establish the claim either based on misrepresentation or breach of the fundamental term of the contract. Okay, there's a but, there's a but. If you are claiming or you are pleading, this is pleading, right? Statement of claim is a pleading. So if you plead under the roof of misrepresentation in this case, the remedy that you get is what? Rescission, you know. But Mrs. Anna and also Mr. Derek already sold the house. So how do you rescind the contract? You agree with me? Can understand at this moment. So what I'm trying to say is, when you read the whole material facts, all right, you read the material facts, subsequently you have to establish what is the ground, what is the course of action inside this statement of claim that you wanted to plead. Okay, you cannot plead something that is already impossible to be performed. Okay, rescission, for example, the house already sold what, and it's already been built. So how do you rescind? Cannot. Misrepresentation to me is a bit out lah. Okay, it's a bit out. So I will formulate my statement of claim based on breach of fundamental terms of contract. So this is how I will draft. Okay, I'll draft. So I will rely on your ABCD. Okay, ABCD on top of this 1.5 million thing lah. Okay, so I will say this way: the plaintiffs and defendant entered into a contract or entered a contract to purchase one unit of bungalow in Kuala Lumpur. It was the terms of the contract, inter alia, or you can use among others also can, no problem. Make yourself comfortable with the drafting. Everybody's drafting style is different. And some more, I'm just giving you my view, you know, some other lecturers or tutors may give you their own interpretation on what is the course of action available, because the facts given is very limited. So I have to do it in my own presumption. I mean, presumption as well as the safe approach. This one, but you wouldn't go quite wrong. You wouldn't go wrong, I would say. Okay, inter alia, number one, I will put the purchase price of the bungalow is at 1.5 million. You have to write 1, comma, 500, comma, follow with 30.00. You must write in numerical form. You cannot just write 1.5 million. It's wrong in the format. Okay, very important, please. And then second thing, second term onwards, you can appreciate that I extract completely from the fact. Why I extract those terms from the fact is because it's already been provided. Do not think of your own sentence on how to formulate these terms and conditions. It's usually provided. Just copy and paste with slight modification, because during exam times, you know how stressed you will be. The first exam, this GP was my first exam. So I was so shaky, I was so nervous when I was tackling the exam question. So comes with survival instinct. You must be familiarized with all this format and how to find the information with numerous practice. I would say really, you have to practice from now how to draft. Don't lose mark in this part. Okay, so you copy and paste all the terms inside. All right, namely the housing estate will be manned 24 hours security. I hope it's with you. It's inside, you can follow me so far. Okay, and up to date. I copy words by words. Nothing will go wrong because you plead facts. All right, you plead facts given. Okay, so these are the 5 fundamental terms of the contract. Okay, first you establish, okay, they enter into a contract and there are some terms of the contract. Then subsequently, you must mention in your statement of claim that the plaintiff had done whatever obligation that is provided inside the contract, correct? So this is coming in your paragraph 5. So in compliance with the terms of the contract, the plaintiff had duly performed the following. Okay, so what I write here, paid 1.5 million ringgit to the defendant. Okay. And then I want to continue my story because the court will look at this because before we go to trial, this is what the story, the cause of action, everything is from here, is from statement of claim. So you must really learn how to draft a SOC well lah. Okay, and a few senior lawyers from MOA lah, actually, they told me from this statement of claim, they can see your level, of advocacy. My one is of course entry level lah, because I just joined one. Okay, entry level. Okay, different lawyers, they have a usage of words is very unique. But for the sake of CLP, you can take my SOC as your personal reference. No harm, no harm. Okay, if you have met any, or I mean, if you have discovered any mistake or any room for improvement, please do let me know in return, please. Okay, so I will plead further and say, after delivery of vacant possession. So where we can see this sentence, you can see it in the next page, in your page 3 of your question. Did you see? After delivery of vacant possession of the bungalow lot, both plaintiffs moved in. They were to discover in the short period of 2 weeks the following. Okay, I want to say there's some breach already. So how do I put in? Is everybody has their way lah. Okay, you can put in breach of the terms of the contract the defendant had, you can put, also can, but I prefer to follow facts because I really don't want to think during the examination. So I put in, again, what are the breaches? You can see it in Roman 1, Roman 2, and Roman 3. I copy every single word inside the SOC. For example, the guardhouse was manned by only 2 guards who could not be located most of the time. And second, the burglar and fire alarm system in plaintiff's bungalow unit were not functioning despite repeated complaints to the defendant. And the third, copy exactly the lack of security. Okay, at this this is a little bit because I drafted today, so I don't have time to check the spelling. You cannot make this sort of gross mistake during examination. Every words must be precise. At the guardhouse, caused motorbike riders coming into their estate and carrying out illegal motorcycle race. Okay, and then I continue with my story. The plaintiff has suffered damages due to the said breach. These are the breach lah. This is my way of drafting the SOC. Okay, it could be a variation, but it's still okay. It's still okay as long as you tell the court in a systematic and chronological order about what happened to the story. Then I think you will not go too wrong lah. Okay, and then you write further. Due to the said breach, the plaintiffs were forced to move out their bungalow. Again, you see, I copy exactly what they said in the last paragraph. Did you read? After a month, the situation became unbearable for Mr. and Mrs. Gulliver, and you're forced to move out. Okay, so I continue with this sort of sentence. Every single words I copy. All right, I copy. Okay, move out their bungalow and eventually sold it for lower price, 800,000 ringgit, also in numerical form. Important, this one is seriously important. So the second plaintiff had also suffered from a nervous breakdown, which required medical treatment. All right, so you put all together. And then I conclude, okay, therefore the plaintiffs have been put to loss and expenses and has thereby suffer damages. This one, please memorize lah. Okay, please memorize lah. And I will write here my special damages. What are the special damages that incurred on the plaintiffs? Okay, you can find the information from the last paragraph of the question as well, which is the loss due to the sale of bungalow. If you deduct from the purchase price 1.5 million with the current price of the house that the couple sold to the other party, you get 700,000. So plead. The second being this Anna Global didn't need some treatment for for her psychiatry problem. So you also plead here. So this will give you mark during examination because you plead according to the question asked, All right. And then finally you conclude. This is standard format you must follow. And the plaintiff claims special damages in the sum of 1 million ringgit. Okay. From here, this is your special damages. And general damages, okay, interest, cost, and such further and other relief as this honorable court deemed fit and proper to grant. Please memorize this paragraph. Okay, please memorize. And your date here, I will prefer that you put the date of examination. No need to think. Come in an instinct, just write date. Your examination, I think, shall be on 17th of July. So just put 17th day of July 2023 and then sign. Okay, sign and then put dots, solicitors for plaintiff. All right. And then you put it at the end of your page, this particular page. This statement of claim is filed by Tetuan Chris and partner, the solicitor for plaintiff, okay, whose address for service is at so and so. This one also, you better put down your own address because now you don't think of new address to write in. Write in whatever that can come into your reflex, You know what I mean by reflex? Automatically, you no need to go to your brain. Go from your spinal cord. Okay, go to your hand. That is called reflex. Okay, no need to think one. Just write. And then put in the phone number as well as fax number. Sometimes you put in some telephone, the email is also allowed, no problem. Okay, so these are the format, okay? And another important point that I want to emphasize would be you must space, you must space at least one line. The examination sheet will be coming something like this. Okay, it will come in this. You must space. This is confirmed because it's provided inside the Order 18 as well. So you must follow. You must you must do spacing. Okay. Instead of the law firm name, we need to write our name. No need. Just write solicitor for the plaintiff. You mean here, is it? Just sign and solicitors for plaintiff. Okay. No need to write for example, me, HBC. No. Just write solicitors for plaintiff will do. And then most important here, you already identify yourself. Here. Okay, Tetuan Chris and partner. So this is me who submit the claim, the statement of claim. All right. So as simple as that. Any question you want to ask about statement of claim, please memorize and practice every day, I still remember when I study for my CLP, with Mr. Patiban. Okay, Mr. Patiban had guided me well in drafting statement of claim. He asked me, really, this is what I did as well. I did statement of claim every night before I slept. It will take you about 5 minutes, trust me. Okay, but once you master this statement of claim, to fail general paper is a little bit farther away from you, Okay, so you must know all this because the amount of marks given to statement of claim sometimes can reach 20 marks, So if you can gain about 15 to 20, 15 marks out of 20, I think it's quite good, isn't it? It helps you, all right? So please do paragraphing, spacing, and numerical form, and write the story based on how you want to let the court to establish cause of action. This is a typical example of a breach of contract. Each line must space it. Yes. In practice, in fact, this is what we do as well. All right. You don't space, You cannot want, you know. Seriously, cannot want. The registrar sometimes can reject your statement of claim. Then you have to find amendment. A lot of tedious work. So I would recommend you to write statement of claim instead of typing inside the computer. It doesn't work. I myself, I write. Okay, I write. But for the sake of teaching, I wait. I have to draft in this manner lah. The first part. Isn't this breach of collateral contract? It doesn't matter. It doesn't matter. So long you said that even collateral. Okay, you go back to my previous lecture. Collateral damage, collateral contract exists side by side with the principal contract. The main contract is there for the house. Okay, the collateral damage you also can claim for breach of the fundamental terms of the collateral damage, you know, collateral contract, you know. Okay, that means the collateral contract is recognized by the court. So you don't plead, oh, there's a principal contract here, there's a collateral contract here. No, you don't put the information here. This is as a matter of operation of law. You don't put it inside the statement of claim. You only plead the facts, fakta sahaja, whatever the story given by the question. You do not plead what you know from the textbook. All right. So you can still claim. It's still a breach of contract. Doesn't matter. Okay. Possible to do SOC first. Yes, very possible. A lot of people did that. As long as you don't get your thought wrong lah. Sometimes you have to calculate the loss of future earning first before you can determine the monetary value of especially for top case lah. Okay, but if the case is so clear cut, it's only about one course of action. Actually, you can go. No issue. Right? So can I understand this statement of claim? The format you must memorize by your heart now. Okay, memorize. So if there's no question, I think we better move to. Okay, we move to the thought question. Okay, the medical negligence thing. So you must read the question properly, you know, because this question, are you able to see the question? You are approached by Dustin Holman. The question Dustin Holman thing. Okay, you must be able to follow. Let me share my screen. Okay, we are discussing question 2C now. 2C now. Settle a statement of claim to be filed against the person or persons liable for such damage for medical negligence. So, okay. Okay, we go to the question. All right. First, we have to achieve some consensus. By equitable remedies, we have to yes, if it requires you so. For example, you want to plead some specific performance. Yes, you can do so. You can plead injunction. But rarely it happens, you know. Rarely it happens. They will make first question 1A and 1B or 2A, 2B rather complicated, but not for the SOC. You know. SOC is the best chance for you to score actually. All right. I have never seen for the past 3 years at least the paper asks us to plead about equitable relief. I never come across that. Usually it's the amount of damages. Okay. So if it is so, you have to plead, yes, because equitable remedies and also your injunctions, all that specific performance, it is you must plead. Otherwise, the court will not know, right? So the purpose of statement of claim and statement of defense, okay, subsequently you have those reply, is to let the court know what is going on and what are the relief that you are asking from the court, you know. Okay, so very important. If the special damage 980K, yeah. If it is 980K, near to 1 million, you better plead in high court because it does not cover the general damages yet, you know. If general damages, you must think, a lot of people got confused. They look at special damage. Special damage, you can count straight away, okay? Okay, I'll take you to second example and let you see how we reach high court lah. Okay, first, where's the place? Where's the territorial jurisdiction that we should claim from our defendant? So you can see here, okay, the question asks you to talk about medical negligence, isn't it? Medical negligence. So my stand is very clear for this question. I will not include Pacific Hospital and I will not include government as my defendant because the question is clear. For medical negligence, if you want to sue together this Pacific Hospital as well as government of Malaysia, it will come after vicarious liability. You agree with me on that? Huh? So the parties, I only identify two. Okay, Henry Holman and Dr. Hari. Very tongue twisting word. Okay, so I guess our LPQB has a great sense of humor, you know, in setting out the question. You see the name? So, okay. The defendant is from Pacific Hospital, and the Pacific Hospital is in Kuala Lumpur, supposedly. So where can we find this information? All right. Okay. Where do you go? Wait, He was rushed to Pacific Hospital, correct? And the whole incident happens in Kuala Lumpur. Okay, there's no further elaboration on where this Dr. Hari stay. So you can actually assume. Okay, another good question that raised by our candidate. I actually take note of the condition that suffered by Henry Holman, in which he suffered from quadriplegic as well as permanent loss of most of his sensory movement, bladder, bowel control. Isn't so? Okay, in order for you to bring actions uh, by way of litigation representation, okay, representative LR okay, under order 76 of your rule of court, the person must fulfill two criteria, you know. I mean, the plaintiff must fulfill two criteria. The first one being a minor, less than 18 years old. And second element is unsoundness of mind, you know. Okay, unsoundness of mind, you have to associate it with mental health act. Okay, in this event, the victim, no doubt you are approached by the father, Dustin Holman, but the facts suggested nothing suggesting that the Henry Holman suffer from any mental disability. So my stand would be we sue under his name, okay, in his own capacity. Okay, so I do not think that order 76 will apply here. The person under disability provision will not apply in this manner. Okay, so be clear with that. So we have no issues with the first part in the High Court of Malaya at Kuala Lumpur in the Federal Territory of Malaysia. Please write. Again, I use civil grammar. This is from my firm punya template actually. Wait, civil suite number. Okay, so you put the year, like I say, you dash and dash 2023 for your current exam purpose. You put 2023, you will not go wrong. And then you have to write down IC, XXXX, and then you have to write this word plaintiff. Don't miss anything. And also this word and, okay. Dr. Harry as your defendant. Okay, then you write these statements of claims. Okay, and you always start with the introduction of plaintiff first. Okay, first you said the plaintiff is an individual whose residential address, this is my style, you can say who is residing at also can. Okay, so you can partially get some information from the my son was involved in accident. This paragraph, you can see, the father told you where we reside at block A, block A. So this is the tricky part and also the trap here. Can you just put block A? My stand is no, because it's not precise enough. So this is the perfection of statement of claim that I think all of you must now be very clear. You cannot just put block A. The whole block A belong to this defendant. Cannot be, right? So you must write in something, you have to add in. What is the unit number? Apparently, this look like some sort of apartment or condo, isn't it? So you write the unit number, okay, to show that you are familiarized with our current real life scenario, isn't so? So you intro plaintiff. Second, you intro the defendant, who is also an individual whose residential address, this one is completely fictitious. I add in myself because it was not given here. When it is not given, make sure you don't write dot, 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 dot. No, cannot. You write dot, dot, dot. What does it mean? At least you write this no X Jalan ABC 50540 Kuala Lumpur, Malaysia. It shows that you know, even though this doesn't exist. But you cannot write dot, dot, dot in the exam. You will lose a little bit of mark, I believe. All right. So I further introduce our role of our defendant here. I said all material time, okay, the defendant practice as a consultant specialist surgeon in Pacific Hospital. Okay. So again, you have to be precise here. Where's the location of the hospital? Again, it's not provided. So you have to write. Otherwise, so many Pacific hospital around the country, for example. So which one are you referring to? Please be a little bit more sharp in tackling the question. So I can find the word consultant specialist surgeon at the end of my son here. He was examined by Dr. Hari. So you just said consultant specialist surgeon. Exactly what does the fact provide? Do not write. Yeah, we all know that he's a doctor, but the fact already being very specific said that he's a consultant specialist surgeon. So please write in accordance to the question. All right. So what happened? Next, what happened? So apparently, Henry Holman had met an accident, isn't it? Okay, and then brought to the hospital. So I try to relate this information that I could find, because my style is I always extract the necessary information from the question itself, Something like what I do is like this. This is my approach before I draft this statement of claim. I just share with you the screen. Just bear with me for a moment. Something like this, where I can extract the information, I will straight away highlight, okay? So this paragraph, when I talk about on so and so, it's actually I could found it here. You see, the above name was brought unconscious to this hospital at 9 p.m. on 12th of December 2018. So this is how exactly I copy paste into my statement of claim for this question. Okay, so you get me. Just get information from your problem scenario. Okay, the question itself will provide you foods. All right, so we go on and say that on 12.12.2018 at or about 9 p.m. So I don't have to think, I just rephrase it. The plaintiff was brought unconscious to Pacific Hospital to be specific. Specific a bit lah. Okay, with a history of having been involved in a motor vehicle accident. Okay, so you agree fully with this fact. Can see or not? Am I sharing the right thing? Can see, okay, very good. All right. Okay. Then subsequently, you go back to your question. Because you need to draft your story well, and the information is given here and there. So it's about the recollection of information and put it in the structured manner, So how you see, all right. And then you can continue with the story. You look at the last paragraph of my son was involved in an accident. Are you able to see this? Actually, you must cross refer to the question. Otherwise, I don't think you can follow what I said. I hope you all have this. Okay. So the plaintiff was examined by the defendant, and immediate surgery was done on him to relieve the swelling in his brain. Can see, I copy exactly. I do not make extra sentences, okay? Because most of the time it's not necessary, okay? This is based on my experience in answering a GP question. I think it's not necessary. You can extract the facts from here. And then you can see from the next paragraph, I heard from a nurse, something like that. Okay, so you said something must have happened, isn't it, during the surgery? So you can derive this sentence. During the surgery, the plaintiff, the son, my son went into cardiac arrest due to the lack of oxygen. Okay, so this is very important. Something had went wrong during the surgery, correct? You extract the exact sentence from your question. Can get me? So I will say during the surgery, the plaintiff went into cardiac arrest due to the lack of oxygen. Okay, and then subsequently, I will start to find faults. Blame the defendant. So I will say particular of negligence. Okay, this one also you cannot simply write whatever you know about negligence in medical. Medical negligence per se. You cannot just write everything you know. You have to relate on fact. Remember, SOC is you plead based on facts given. Very important. Very important. Don't simply write there is no still fall below the standard of care. All that actually you are pleading laws already. Okay, negligence we all know have 4 components, correct? Duty, and then breach of duty, and then subsequently causation and damage. But you do not need to write, oh, Bolam test. You put here Bolam test does not follow the standard of generally accepted medical practice. All that you don't put it here. You put it in your answers for question 2A and 2B. This is the time you put in law, but SOC is about fact, so no need to plead all that Bolam, Fufiona, all that, no need. Okay, you just have to see from I heard from a nurse that Dr. Hari's wife had been diagnosed with cancer. Onwards, you can see already. So I will put particulars of negligence exactly according to the question asked. You can see, Dr. Hari failed to notice Henry's vital signs were rapidly declining. Okay, this is first fault. Agree with me? First fault. Okay, I will rephrase in such a way: fail to notice the declination of plaintiff's vital signs. Full stop. Okay. Second, what he said, Dr. Hari could not concentrate fully on the surgery. All right. So this is the second. Fail to concentrate fully on the surgery. Full stop. Please, full stop. Do not engage and be creative, add in, or do not resuscitate lah, fail to take precaution, because it's not inside the fact. Why you bleed? It may create an impression that actually you already pre-plan a script and write inside, No, no, no. Statement of claim is really a fact matter, a matter of facts, cannot add in, okay? Add in new information, okay? Other than the one that required you to do so lah, okay? So, can follow me so far? All right? Can follow me? But in real world, the statement of claim will look much thicker than this. Not just 3 pages thing. It will cost you a few 10 plus page because the story is really long. But for the sake of CLP, you just need to know briefly about how to draft a statement of claim, but in a proper way. All right. So I will continue. Due to the aforesaid negligence on part of the defendant, the plaintiff suffer pain, injury, loss, and damages. This is standard script. You can just write. And then further, you must write what are the injuries that suffered from the plaintiff. All right. So you can see from your specialist medical report, your page 9, appendix B. Okay. You just have to add in the plaintiff was 2 years of age at the time the medical accident, had suffered from quadriplegic, including with permanent loss of most of his sensory movement, including bladder and bowel control. This one, I completely copy and paste from the question, as you can see, because you really have to save time already. No time to think. Otherwise, you think too much. How to write this? How do I formulate in a proper way? You take your sweet time and then let me think how to write. Oh, this sentence, this sentence. Subsequently, you may end up the time is running out. You could not even finish the whole format of the SOC. It will be a losing for you, not so good. Okay, and he will require continuous daily nursing care. This is all I extract exact sentence from facts itself. Okay, please. And then later on, you write the injuries, and then subsequently you have to write the particulars of special damages. All right. So you have to be sharp on what are the facts available to you. Okay, in the question, don't put simply crutches lah, the medicine, nurse, the one that is not necessary. You don't put. Okay, logistic fee lah. Where is the logistic fee that you can see from the facts? You can't, right? So you don't put unnecessary thing to give the impression, like I said already, that you are actually memorizing a script and put in during examination. So this is not good. So you first put in medical bill in Pacific Hospital. So you can see it in the last few paragraphs, very clear here, 120,000 ringgit. Put it in numerical form, and then pre-trial loss of earning, because he's earning 6,000 ringgit from Securities Commission, isn't it? From when to when? Okay, sometimes you can add in the word continuously also can, because you don't know when the trial is going to finish. Nothing wrong, okay? But usually what I'll put is until the date of exam to make it simple. And if you do not have time, these are a few tips and tricks that you can follow. Just write RMA, RMB, RMC. All right, if you cannot calculate and you are running out of time, otherwise you'll end up you have to draft and then how to calculate what is the amount unnecessary unnecessary, no need. All right, so pre-trial nursing care from the date of medical accident until the date of exam. Okay, you can write here also in the bracket continuously also can, RMB, and cost of medical reports, police reports and sketch. This is all given here. You have a medical report, you have a police report, as well as you have a sketch. That's why you must put You must put. It shows that you are reading the question. All right. And this one is standard. I hope you could memorize by now. And the plaintiff claims special damage in the sum of how much? And then follow this. Date, sign, solicitors for plaintiff, and subsequently you end with this sentence. Must memorize. This one, it will be universally applied across all your statement of claim. Okay, don't worry, the samples discussed today subsequently will be shared in the group after I check all the spelling mistake because I have to be careful so that I don't mislead you during the class. Not helpful, never mind. Don't mislead. All right. Okay, we finished with number 2021 paper, and we can move to the statement of claim for our 2022 paper. Right. Can you open now? I also need to open from my tape. All right. This was my paper lah. Statement of claim. Okay, I think today we can finish on time. All right. So, statement of claim 2022. Facts plaintiff's salary state. No. The salary is you don't have, like I say, you better don't spend too much time in calculation. You just write pre-trial. The special damages only apply for pre-trial loss of earning. You don't have to calculate every single loss, okay? You don't have to calculate so much. So you just have to label it with RMA, so long you pleaded so. Okay? Right. So are we able to move to gem obvious question? All right. So gem obvious question is very clear cut. I do not think we will have any issue with the territorial jurisdiction, as well as the High Court of Malaya is the right place to sue the defendant because the amount easily reach more than 1 million is in fact 105. Is it 105 million? So definitely we'll go to High Court, right? So again, this is civil suit number. Suit number. All right. You put the year 2023 for this current exam. Please do so. Right. Nobody had this one student don't have this paper because for me to go to this question paper and share one by one, I think I cannot show you the whole image of this statement of claim. So anyone can, are you in the group? What's this name? Yeah. Okay, great. It's inside the group already. All right. So, okay. So the parties here is clear cut. Only two parties, in fact. Actually, you got three names, but only two parties are contracting with each other. All right. So, okay. Again, gem obvious as well as Michael Cronus. This looks a bit weird to me. The name itself is a bit looks like a foreigner. It's not typical Malaysian. So I put passport number. All right. Show a bit of your sense that you are reading the question. All right. Okay. So plaintiff and also defendant. Okay. Spelling, everything must be correct. And you must put it defendant. And then subsequently, statement of claims. First, you always start with the intro of plaintiff. Here, I will definitely write because the information is not there. So you have to create and put in because address is really important, in statement of claim. You cannot write ... like that, finish. No. So first, you explain this is an individual plaintiff suing on his own capacity. So the plaintiff is an individual, you see. This one is not acceptable. Not acceptable. So you have to put N. So it's better for me to screen through because I just draft all these four statements of claim today. So it may contain some spelling errors. Whose residential address is at number X Jalan ABC. This, if there is no address, please memorize by your heart. This is the format to do. Okay. Postcode Kuala Lumpur, Malaysia. At all material time, plaintiff is an avid collector of painting and has amassed a number of well-known and expensive paintings by old master. Where do I get this information? I copy from the first paragraph of your question. Can you read? You can read. He's an avid collector onwards. I want to explain already. Who is my plaintiff? Can follow? Can follow or not? Can? So extract whatever information that you have, all right? So second, you introduce your defendant. So who is your defendant? Defendant, who has who is an individual as well. You said he's an individual whose residential address. Make it standard lah. Don't suddenly write this one whose residential address, this one living at have a bit of style of drafting. Okay. Number Y, Jalan DF, also Kuala Lumpur. Where do I get the fact that he's living in Kuala Lumpur? Among others, he owns a 3-story detached house in Kuala Lumpur, valued at 9 million. Okay, apparently this guy is also a wealthy man with a 3-story semi-D in Kuala Lumpur. So I put in additional information because I need to sue him in the High Court of Malaya, KL. So I have to put that he actually stay in that house. So I created my own address. Okay. So at all material time, you explain who is your defendant. The defendant is an art dealer. So where I copy this would be in late 2019 paragraph. Can you see? Can you see? Chronos run, sorry, no, it's yeah, a well-known art dealer here. All right. So you can say that from the facts that you can derive from the question, you can write defendant is an art dealer who runs his business from his base in Singapore and has business interests all over the world. Full stop. So clear cut, you already create an idea that the defendant is so and so. Okay. Art dealer, important. All right. And the third being, so you read further in a meeting between Orpheus and Cronus on 9th of December 2019 onwards. Okay, again, here we have to discuss. All right. You want to sue the plaintiff based on what ground, based on what cause of action in this manner. Here you can probably make out that actually there's a fraud, isn't it? Can anybody make out there's a fraud here? There's a fraud? Cannot make out there's a fraud? Can, right? Because if he make the forged copy, isn't so? So you must make out the cause of action and you must plead, Okay. But for the safe side, I also pleaded misrepresentation in this SOC. Subsequently, you can appreciate. If you cannot understand, please ask me back in the group. All right. So this is what I'll tell. Okay. On 9th of December, both plaintiff and defendant had entered into a contract to procure a painting. Okay. It was the terms of the contract inter alia. Against this is my style. Number one, the concert being an authentic, genuine, real, and or all original painting by Johannes Vermeer. Hereinafter, the concert. All right. Okay. There's one funny question. If you cannot recognize the postcode, just put 1, 2, 3, 4, 5 or 5,000, 8,000. Okay, it doesn't matter. So long you put rather than you miss this piece of information. You will be rather than I don't think you'll be penalized so long you put the information there. All right. So okay, it was the terms of the contract, inter alia, the concert, all right. Okay, I already said that. And then what is the performance of the obligation of plaintiff? Okay, the plaintiff agreed to pay 90 million. So you must calculate the zero accurately. You miss 10, the claims will not be correct, So please, this is tricky. So I spent a lot of time during examination to write zero accurately. Okay, for the price of the concert, as you can see here, this one I found it, I cannot extract much of the facts from the question itself. I cannot directly copy and cut, but I have to modify according to my understanding. Okay, so this is the price for the concert, the painting, and on top of that, there's also an agreed price for the service rendered by the defendant. Isn't so? The 15 million. So this could be one of the terms inside the contract. Plaintiff agreed to pay defendant 15 million. Again, must put 00, okay? Cannot write 15 million, for his services, open procurement of the concert. Okay, then subsequently, the defendant shall procure the concert in North Korea at or before the end of September 2020. Here, I'm trying to highlight that the time could be an essence because I don't want him to pick. Okay, this one is a forgery. Okay, I give you an example. This one is forgery. Actually, I have not done the contract yet. Actually, the real one is still in North Korea. Because of COVID, I cannot go to North Korea. So later on, I becomes a defense to your plea, So I put this on purpose. This is as a matter of the fact you can write, you can get from the problem scenario as well. Okay, so and then you continue by writing by August 2020, the defendant had paid an art forger to recreate a painting identical to the concert. And then this is apparently you can see it from on page 4 of your question. Okay, on page 4, just copy directly. Okay, because there's some element of fraud, Okay, so based on my understanding about this question, you want to claim the market price of 200 million over this your loss. It may not be falling under the remoteness of the damage test, So I plead fraud as well. You can see, okay, on 15 August 2020, the plaintiff falsely informed the plaintiff that he was in North Korea and managed to locate the concert. So this is already some element of fraud going on, okay? And in compliance, again, you be safe, be safe. So I write both here. In compliance with the terms of the contract and or reliance to the statement made by the defendant, the plaintiff had duly performed the following. You can see the facts here. Okay, open delivery. He straight away paid for the 90 million into the defendant's Maybank account in Singapore as the price of the concert on 17th of August 2020. All right, you can see from the facts which paragraph. Yeah, as he was convinced that Kronos had secured the painting. Okay, you can copy exactly the facts given here, 90 million bank to Maybank Singapore. Okay, then subsequently paid 15 million to defendant open receiving the concert on 20 August 2020. Okay, so you have to formulate based on the question given. All right, you must be exact. All right. There will be recording. Don't worry. My voice is loud and clear today. I do not have this hoarseness of voice, so I think I can share the video all over. So on 12, what happened? On 12th of September, you see the recently one, 12.9.2020. This one I want to plead, section 19, subrule 2, because my plaintiff is innocent and there's a fraud element. My plaintiff cannot discover the authenticity of this painting by his own due diligence. So I write in such a way. On 12, what happened? Actually, he had a dinner, isn't it? So the plaintiff had informed by one Charles Windsor, the chairman of Sotheby's chairman, okay, as an expert in old master paintings, that the concert procured by the defendant was a forgery. Okay, I plead here. Don't miss, I plead here. Okay, subsequently, I'm gonna end with due to the said breach. So you can see, actually I'm pleading on a few grounds, One is breach of the fundamental terms of the contract. Second is based on the vitiating factors, okay? The fraud or misrepresentation by the defendant on the free consent of my plaintiff, okay? Because personally, I think even though Mr. Charles Windsor has said that the original value can be actually 200 million, but is it within the reasonable contemplation of the parties? Did the defendant aware of about the 20 million? So I think it will be a little bit extraordinary loss. So cannot claim now. Maybe cannot claim now, right? Unless you have real evidence to support that. But from the facts itself, I do not see. So I pleaded all. So because fraud, you can rescind. Rescind, you will get the 105 million, which initially he asked from the defendant, All right. So 105, if you rescind, I return to you the forged painting, and you return to me 90 million plus the 15 million service fee. As simple as that. Everybody happy. All right. So this is how I want to establish during this statement of claim here. All right. And then subsequently, you write your particulars of damages. Don't just write everything plus the payment 105 million. No, you have to separate to show that you are reading the question precisely. Okay, so payment for the concert as well as payment for services, please write in numerical form, 105 million altogether, and this will be your standard and dated, signed, solicitors for plaintiff, like this. All right, clear. And then okay, still run out of time. Okay, never mind. We just go with the last statement of claim. Last statement of claim, it will be 2022 top paper. Okay, 2022 paper, they specifically ask you to write. This is something very new. Draft a statement of claim to be filed against the person or persons liable for damage for occupier's liability. Okay, occupier's liability. Ayo, this is no lah. This is session court lah. Session court. All right. Okay. So everybody agree with me. The right forum shall be in the session court at Seremban, where Gaia Management Corporation is located. So you can agree with me on this fact. Okay, because the amount, judging how I calculate the loss of, even I calculate the loss of future earning, Raj was merely earning about 3,000 minus living cost 1,000 minus EPF minus plus EPF minus income tax. It will be give rise to maximum 15,000. So after in calculation together with multiplier, I think I get the sum nearly around 250,000. So I think the right court here would be session court. Okay, nobody has issue with this session court. And we change a bit. In session court, we do not use civil suit number, but instead we use summon number. okay, summon number, and you put the year behind that, okay, and the party between. Between, you cannot write Raj, you have to get the information from Hospital Tuanku Jafar Seremban, Appendix A, your page 9 of your 2022 paper, in which there's a name medical report on M, okay, M, there's a dot here, very blur, I didn't see also. There's a dot here, okay, M dot Raja Sekaran, and then it provide you with NRIC number. Please copy exactly from here. 900405017777. Then you name Mr. M. Rajasekaran here as your plaintiff. Okay, so nobody has dispute over the plaintiff issue. I have a little bit question about who to name as defendant. Okay, remember I told you in my top class that in occupier's liability, you have to establish the definition part. You have to establish what is the premise, and second part, what is who is the occupiers. Okay, here if you read the question, the question go in such a way. There's a power breakdown in Gaia Shopping Complex, okay, which is probably managed by this Gaia Management Corporation, GMC. And then subsequently, GMC engaged with Alibaba, engaged with Alibaba to do construction, to do this repair works, at this particular premise, So I have a bit of doubt initially. Alibaba should be the contractor, correct? And then the plaintiff here, Mr. Raj, is the subcon that do the electrical cable jointing works of the main con. Main con, Alibaba. Subcon, K Baka Enterprise. And then K Baka Enterprise employs M. Raja Sekran, okay, Raj lah. Okay, so you see who had the control over the premise. Okay, I will submit Gaia Management Corporation, reason being because Alibaba actually did not send any representation there. So it cannot be said that Alibaba, even though he's being a man con at the site, I mean the electrical repair site, he cannot be said as a person who has control. There is a proximity to sue Alibaba actually. You can establish negligence. There is a contractual liability as well. You can see because he's the one that engaged K Baka. Okay. So no, don't go haywire. This is about occupier's liability. So we need to know who has control over the premise. Okay, who has control? Very important. So I submit that Gaia Management Corporation has a control and therefore should be named as the defendant. Okay, so I introduce the plaintiff. Again, I introduce the plaintiff. Okay. Okay. Oh, this one I think I made a mistake. I need to amend later. So plaintiff is an individual whose residential address, again, you make a fictitious one. This one apparently I copy from the previous 2021 answer. And at all material time, you introduce further, plaintiff was working under the employment of K Bata Enterprise to carry out electrical cable jointing works. You can see in the second paragraph, okay? Second paragraph, because clearly they said that the K Baka Enterprise is their employer. Kasim Baka is the employer of Raj. So you can derive your facts here and then you put accordingly to introduce who is the plaintiff, okay? So it's very clear already from this sentence, working under employment to carry out electrical cable jointing works. And then subsequently, you introduce to the court who is the defendant. The defendant is a private limited company registered against Standard Format Companies Act 2016 and having its registered office at 123 Jalan MBC 70,000 Seremban, Negeri Sembilan. This one, just now somebody asked me about the postcode. You can write lah, you can write, simply guess lah, okay? At all material time, the defendant is the Management Corporation for Gaya Shopping Complex, Seremban. Hereinafter, premise, okay? You must fit in and define it as premise lah. You must name it as premise because occupier's liability, the key word here is the premise, okay? Or the building also can, okay? There's one question, Management Corporation is not a company. It could be true, you know, it could be true. This one I have to counter check with my senior and see. Management Corporation, not company. It could be true. Let me just check and then get back to you, okay? But this, the intro you must give and establish that the defendant is actually the occupier, all right? And then what happened next is, on 5th of February, the plaintiff was sent by his employer to carry out the cable jointing works in the premise, okay? This one is very important. So what is the purpose? Under which, I mean, either his invitees or contractual entrance. So this one, you make it based on the fact, okay? The plaintiff worked for the K Kasim, which you have described, K Baka enterprise, and then he was sent by his employer to carry out the cable jointing works in the premise. So this one, roughly you already established, you know, what is the nexus between the occupiers and as well as the claimant, which is, in my opinion, would be invitees lah. I think it's invitees lah. Okay, because there's no direct contractual relationship between him as well as the occupier, who is the defendant. So I further elaborate what is the fact here. At or about 2 p.m., an explosion occurred and had caused the plaintiff to be injured badly. So this is what I copy down in on the paragraph on 5th of February. Can you see? So this is how I establish, okay? Explosion had happened and caused the plaintiff to be injured badly. Copy out bulat-bulat. And then fourth, I said that the aforesaid explosion was caused wholly or partly by the negligence of the defendant. As we have discussed before, occupier's liability could be one of the species of negligence. So I pleaded as follows. So particulars of negligence here. Where is it? I wish to state either Alibaba or GMC. Okay, so I submitted so in accordance to the fact given. So they failed to cut off the power supply. Okay, this is the first. Second, failed to ensure the workplace was safe. Okay, and then the third being failed to ensure that a competent person was present, okay, during the repair works. Okay, so these are the three particulars that I could get from the facts. All right, even though most of the time occupier's liability, you can plead no notice, no warning, you know. But in the given scenario of year 2022, I think Mr. P. Singh was there, right? Mr. P. Singh already gave a prior warning to our plaintiff that he should not do during business hour. He should not do the repair works during business hours. So you cannot plead notice here. All right, you cannot plead. You must plead according to whatever facts that you have in hand. All right. So Later on, I said, due to the negligence on part of the defendant, the plaintiff suffer pain, injury, loss, and damages. All right. So this is standard as well. And then you plead the particular of the injuries. I think you can get it. You can get it from the Tapole Pakai Hospital, Appendix B, page 10. Okay, you just have to put in the age. Okay, you deduct from the year of examination. Okay, so the plaintiff was born in year 1990, so therefore I give this 32 years of age at the time of explosion, and then he had suffered what injury? I copy exactly according to A, B, C, D, E. Because like I say, if you can copy, you better copy. So, okay. No. Occupier's liability is totally different from vicarious liability. Like vicarious liability, there's a no, it's not being asked here. Vicarious liability is you must fit the employer-employee relationship and then must prove the negligence happened in the course of employment, and the employee must be negligent. It's different type of cause of uh yeah, he was employed, but this is not about the what we call the vicarious liability here. It's about occupier's liability. Yeah, you can go through my first lecture about tort and get an understanding about this occupier's liability issue. It's different, different species altogether. We are talking about the different course of action altogether. Okay, so this one I copy directly, and particulars of special damages also you must refer back on whatever you have inside the question. Okay, I can see there's a medical bill in Tak Boleh Pakai Hospital, 50,000. You can see in the medical bill in the private hospital. Okay, the private hospital here refer to Boleh Pakai Hospital lah. Just speak specifically 50,000. And then actually you can see two medical report, isn't it? Dr. Yong and also Dr. Wikesh. So apparently this Mr. Raj here was admitted to Hospital Tuanku Jafar, Seremban 1, the government, but he requests an own risk discharge and he transferred to new hospital, the private hospital lah. Okay, so this is how medical bill in Hospital Tuanku Jafar come into place, and then you can write pre-trial loss of earning. But here there's one attention that I must draw to you. He said he received his salary until April 2020. So be a little bit sharp here. I start my pre-trial loss of earning from 1st of May. This is my reasoning until the date of examination. So I conclude it as RMB. Okay. And then we have a cost of medical reports. That's it. As special damages. I hope I don't miss anything. Right. So I don't calculate most of the time, but I will write RMXYZ, and this will be your standard. And the plaintiff claims, special damage, all that, you must follow, you must memorize, and you must sign. Please sign. And then solicitors for the plaintiff. Okay? All right. This I will share further in this group later, the SOC as well as the slide. I will get back to our student here. The GMC is not the corporation. Actually, I have a doubt with this issue as well. So I did not check, Actually, I did not check lah, to be honest. I have to check and then I get back to you. This Mr. Ng here, right? So never mind. I think this is the end of our lecture for today. Thank you very much for attending, and I will send the recording to the groups later. Okay? I think we should see you all. Right. Thank you so much for attending. Thank you. I hope you learned something. Thank you. Right. You all can leave. You all can leave. Thank you so much.
Thank you, doctor.
No problem. Please, take your time to leave.
Thank you, doctor.
No problem. See you.